These little mini lectures will follow along with the PowerPoint on medical assistance in dying, which we're going to be talking about in week 4 of our lecture series. And I just want to turn to the second slide, which talks a little bit about the history of medical assistance in dying. The framework we often talk about is the difference between the quality of life and the quantity of life. And now, while we're very focused on the question of quality of life, it's important to note that in the last 100 years, we've essentially doubled our lifespan. So extending life really was a key focus for the last sort of 100 years, the last 50 years in particular. But we do see that there are some new thoughts with regards to issues of palliative and hospice care, which crop up really in the 60s in Canada, and then obviously they blossom and flourish in the years to follow. We also see in the 80s discussions about law commissions, law reforms. We start having some discourse around euthanasia and assistance dying. And we see that in 1992, there was a case in Quebec called Nancy B., which upheld a woman's right to refuse treatment, even if it would lead to her own death. But turning to the next slide, we see that really the question of assisted suicide came up most startlingly when Sue Rodriguez, who had ALS, decided she was going to take the case forward, and she moved it from British Columbia at the trial level, where she lost, and then she appealed to the Court of Appeal, where she lost as well, and then she appealed to the Supreme Court of Canada, arguing that the prohibition against assistance in dying violated her charter rights, particularly Section 7, which was the right essentially to live your life the way you want to, the right to freedom and liberty and so on, and then the Section 15 right on the basis of equality. She had a disability. And at that point, it was 5-4. So it was barely failed. And while they said that, indeed, that there was a violation of Section 15, equality rights, because she was a disabled person, it was saved by what's called Section 1 of the Charter, which says, well, even if there was a technical violation, it was okay because it was saved by a reasonable limitation, so that there was a public reason that was bigger than her, which ensured that at that point, the law did not yet change. Turning to the next slide, you see that the mid-90s, inspired by some of this discourse and the Rodriguez decision, the Senate strikes a special committee, which goes into a 14-month review. And again, they decided against decriminalization or indeed legalization of assisted living, so assisted death. So we see that you could either decriminalize it and then kind of leave it as a vacuum, or you could legalize it. At that point, we see a couple of big cases coming up. Remember, many of you will remember the Latimer case, where the father had a very disabled child and actually performed an assisted death on that child, and he did go to jail for murder. We see also the rise of the Kevorkian in the US. We see the rise as well of the organization called Dying with Dignity, both in Canada and across its counterpart. Turning to the next slide, you see that in the 2000s, there really is quite a lot of movement. So the regulator of Quebec, who oversees medical regulation, appoints a 3-year working group which recommends clinical interventions in some cases. And then again in 2012, Quebec, leading the way, has a legislative committee on dying with dignity. We see at that point from Royal Society of Canada, which is an academic society, publishes a very broad multidisciplinary review on end-of-life issues, which includes assisted death. And then in 2014, Quebec passes its law, an act respecting the end-of-life care, and it was effective as of December 15th. And then we get to Carter, and we've passed the Carter decision and put it into the materials that you have as well. But in this particular case, in 2011, 2 family members of Kay Carter, who had spouse stenosis, were challenging and supporting the right of Kay to have an assisted death. As well, there was one other case that went along with it, the Gloria Taylor case, and that was intervened with the BC Civil Liberties Association. And this really was a big change, because by the time it got to Supreme Court of Canada, they had rethought the Rodriguez decision, essentially. They had overruled themselves and said that now there's enough thought and development and public opinion had shifted such that the Carter decision was held 9-0. And they said that it was against the charter. But what was very important is that they said, okay, it will be decriminalized, but we will be silent on the question about whether the person has mental capacity, whether or not they are able to also have this particular right. And that becomes the center focus of our thoughts for the next several years. So we have Bill C-14 and the decriminalization of MAID. So after the Carter decision, the government, at that point it was the Harper government, left power and the Trudeau government came in. The Trudeau government asked for an extension of time so that they could bring in a thoughtful piece of legislation, which was known as Bill C-14, and whether or not it's what you wanted depends on the opinion of the person at the time. But they do amend the criminal code, and they make a medical assistance in dying legal, and there is, on June 17th, 2016, royal assent given for a statutory framework of MAID. And we'll move to the next little video where we talk about what that statutory framework is.